Good afternoon.
P429, 2024, Honorable Kawira versus the State of the Senate of Kenya.
Here, Mr. Elisha Ongoya, who is appearing virtually.
For the petitioner.
For the petitioner, I have also Collins Mwenda, present in court. I have Edgar Busiega, present in court. Brida Kemathi, appearing virtually. Robert Mutembei, appearing virtually.
Yes.
And my learned friend, Mr. Munene, alongside Masi Tanje, who should be joining us virtually.
Yes.
Then we should join. We appear for the respondent.
First interested party.
Good afternoon, my lord. I appear alongside Ms. Ngata.
I was not able to appear at noon. I was still winding up my virtual cause list. The ruling is ready. Let me just bring it up. Application dated 21st August 2024 and the respondent's notice of motion application dated 3rd September 2024. It's a 31-page ruling, so I will not read all of it. I set out the background to the matters from paragraph 1 till paragraph 12. I then cover the relative positions of the parties and the documents filed, just an explanation of what has been filed between paragraphs 13 all the way to paragraph 15. So I'll begin with paragraph 16, which is the for determination. Paragraph 16. The parties are in agreement on the issues for determination in this ruling, and they have largely cited the same authorities or authorities articulating the same or similar points of law in support of their relative positions and in opposition of the positions being taken by the parties on the opposite side of the matter. From the applications, the affidavits, and the written submissions, it emerges that the issues for determination are as follows. A. Whether the petitioner has demonstrated a prima facie case with a likelihood of success. B. Whether the respondent has approached the court with clean hands. C. Whether the petition would be rendered nugatory if the conservatory orders sought were denied and were not extended to cover the hearing and determination of the petition. D. Whether the respective applicants would suffer an irreversible and irreparable prejudice if their respective application did not succeed. E. Where does the public interest lie? And F. Costs. So at paragraph 18, I begin the analysis. On the first issue for determination, whether the petition discloses a prima facie case, the applicable legal standard for considering whether a prima facie case has been established in a constitutional petition is whether or not the petition in question raises arguable or triable issues of a nature that calls for a response or rebuttal from the party or parties on the opposite side of the dispute, and which arguable or triable issues have a likelihood of success. Put another way, the arguable or triable issues raised in the petition must be of a nature that, if the party or parties on the opposite side of the dispute failed to respond and rebut the position advanced in the petition in question would have a likelihood of succeeding. I must make clear from the outset that in determining the question of prima facie case at the interlocutory stage, the court must ensure that it does not delve into the relative merits or demerits of the contested legal and factual positions at issue in the petition. The role of the judge is to weigh those contested legal and factual positions to determine if, on the face of it, the petition raises issues that should be canvassed at full hearing of the petition, rather than being dismissed at the preliminary stages. and the petition has a likelihood of success if the matter were to proceed to finality. It is clear that the petition herein raises arguable and triable issues that require hearing and determination post the interlocutory stage. This is not to say that those arguable and triable issues, such as questions of fair hearing, public participation, sub judice, and others, shall necessarily succeed. But they are most certainly of a nature and weight that make them fit and proper for full hearing and determination. This is not to say that the court has, at this stage, formed an opinion on the counter-arguments by the respondent, and to a lesser extent by the third interested party. That the petition is essentially incapable of determination in favor of the petitioner for the reason that the position of governor is a public office position with respect to which there can be no private need or expectation to hold office, a position adopted by the Supreme Court of Kenya in the case of County Assemblies Forum versus Attorney General and 3 others, being Supreme Court Petition number 22 of 2017, KESC 58 KLR. That assertion is one best suited for articulation and determination at the main stage rather than at this interlocutory stage. Similarly, the position taken by the respondent and the third interested party that the failure to join the Senate and the County Assembly of Meru is fatal to the petition, a petition which was strenuously opposed by the petitioner and the first interested party in their respective written submissions, is one best left for the petition stage of this matter, for the reason that the modalities and confines of the interlocutory stage do not lend themselves to an adequate articulation and consideration of matters that go to the heart of whether the petition is merited or not, or if the petition is fatally defective or not. To hold otherwise would be to blur, if not completely eliminate, the distinction between the interlocutory and main stages of the hearing and determination of a petition. The second issue for determination is whether the petitioner approached this court with clean hands. The respondent, in advancing this argument, has at paragraph 40 submissions contended that the petitioner misled this court into granting ex parte interim conservatory orders by not disclosing to this court that the ruling by the Honorable Mr. Justice L. Kassan in Meru High Court Constitutional Petition number E013 of 2024 related to a motion of impeachment by the County Assembly dated 17th July 2024 and not the subject motion of impeachment by the County Assembly dated 31st July 2024 upon which the Senate acted. The question of approaching the court with clean hands is a fundamental one. The issuance of interim conservatory orders ex parte is at the discretion of the court, and should it be subsequently shown to the court that the interim conservatory orders issued by the court ex parte were obtained by the applicant through willful misrepresentation, non-disclosure of material facts, or any other similar conduct, then those orders would be at peril of being discharged, set aside, or vacated, with the further consequence that the applicant would also likely not be in a position to obtain those orders at the conclusion of the hearing and determination of the application that was tainted by the applicant's initial bad faith and conduct. The respondent, in support of its proposition that the petitioner approached this court and subsequently obtained interim relief based on unclean hands, cited Caliph Properties Limited versus Babel, Sharma and another, citation given, which was cited with approval in the High Court succession cause of Mongare versus Kerubo, succession cause number E016 of 2023, where the High Court restated the age-old principle that equitable reliefs cannot be issued in favor of a party who has approached the court with unclean hands, and that party's application for injunctive orders must necessarily fail on that ground alone. The petitioner indeed relied extensively in her depositions on what she saw as the sub judice conduct of both the County Assembly of Meru as well as the Senate with respect to the ruling and orders of the Honorable Mr. Justice L. Kassan. However, and similarly to the position taken by this court earlier on the question of Prima facie case, I find that a determination of the merits or otherwise of this issue is best reserved for the main stage, rather due to the nature of the contested facts advanced by the petitioner on one hand versus the respondent on the other. Were it a clear-cut case of unclean hands, which this court could identify and determine at the interlocutory stage, then this court would have no hesitation in doing and determining that question, even at the interlocutory stage. In the present case, the allegation being articulated by the respondent is far more nuanced than the stark instances that were demonstrated in the cases cited by the respondent, and as such, that limb is best reserved for the main stage. Pardon me. All 5 parties before this court in this matter have submitted extensively on the question of whether the petition would be rendered nugatory if the conservatory orders sought were denied and are not extended to cover the hearing and determination of the petition, the third issue for determination in this ruling. The petitioner, the first interested party, and the second interested party have taken the position that without interim conservatory orders in place at the moment, the petitioner, the first interested party, and the second interested party have taken the position that without the interim conservatory orders in place at the moment being confirmed and extended to the full hearing and determination of the petition, then the petition would be reduced to an academic exercise. Paragraph 11 of the petitioner's written submissions dated 4th September 2024 succinctly articulates the position of the petitioner and the first and second interested parties on this question. It reads as follows. Paragraph 11 of those written submissions. It is our humble submission that the petition should be heard without disrupting the status quo, as failure to grant conservatory orders would render the petition a mere academic exercise of no effect. Indeed, disallowing the application would have the indirect effect of denying the prayers in the petition, given the irreversible nature of the series of political actions that would follow. We invite the court to take judicial notice of the operations of any government where a change of the governor or president comes with far-reaching ramifications that would not be desired in the pendency of the petition to be determined. Close of quotes. The second interested party added its voice to this question in support of the confirmation of the conservatory orders in force by stating at paragraph 27 of its written submissions dated 2nd October 2024 that, paragraph 27, the conservatory orders sought are to maintain the status quo until the issues of violation of the petitioner's constitutional rights are heard and determined to finality. Your Lordship, the process of the impeaching the petitioner ought to be interrogated in order for this honourable court to reach a fair and just determination in the circumstances. Unless the conservatory's orders sought are issued, the petition herein shall be rendered otiose. Unsurprisingly, the respondent and the third interested party are of a diametrically opposite view, but for different reasons. I'm just increasing the font. Perhaps I'm commonly referred to as the Mutunga rules, and the latter, being specific to this arena, should take primacy. Rule 23 of the Mutunga rules, and whose marginal note is conservatory or interim orders, does not make any mention of a time limitation on the pendency of interim orders issued ex parte, nor is there any mention of any other requirement, such as the consent of the parties either in that rule or elsewhere in the rules. The Supreme Court has also on several occasions, such as in Gatirao Peter Munyo versus Dixon Mwenda Kithinji 2014 EKLR, made clear that there is a significant distinction between interlocutory injunctions in private law on one hand and conservatory orders in public law on the other. Therefore, the principles and procedures for interlocutory injunctions in private law cannot be seamlessly applied to conservatory orders in public law. The respondent, on its part, has taken a different route, albeit to the same destination. The respondent, at paragraphs 29 and 30 of its written submissions, argues that the petition herein cannot be rendered nugatory on account of a failure to confirm and extend the interim orders in place, since the High Court has the requisite power to undo any actions that would have taken place subsequent to a refusal to confirm and extend the interim conservatory orders in place. In determining this limb, it must be said that each petition is unique and must be considered based on the specific facts, allegations, and circumstances at issue in that particular case. The failure to grant or confirm and extend interim conservatory orders may render one petition concerning impeachment likely nugatory, but not another, based on the unique facts, allegations, and circumstances of each. A uniform, robotic, or formalistic approach to the question of a petition potentially being rendered nugatory does not interim orders already in place were not confirmed and extended to the full hearing and determination of the petition herein. If the interim orders in force were not confirmed and extended as prayed by the petitioner, there would be a succession in the office of the governor of the county, and with it, the likelihood of changes in the staffing of the executive committee and other key offices, a change in the policy and direction of the county, among others. Those changes would not be easy to undo, would not be as easy to undo as the respondent has suggested, even for the High Court, and arguably they may even be beyond the capability of this court to realistically and meaningfully undo. Were those actions to occur, then a large swathe of the grievances that brought the petitioner to court would perhaps be determined by the actions and decisions taken outside of the court process. To this court's mind, the alternative of preserving the substratum of the petition for a few more months, for the few more months that it would take to hear and determine the petition and arrive at a final determination of the dispute before the court, is more prudent and just avenue to take. The fourth question, whether the respective applicants would suffer an irreversible and irreparable prejudice if their respective application did not succeed, is one which is somewhat related to the nugatory question and is being determined separately, as it was extensively canvassed as such by the respondent. Further, whether it is an applicable limb, limb within the grant of conservatory orders is not necessarily the question, since the respondent has submitted on this point extensively. It is clear to my mind that the respondent and also the Senate have no real or significant prejudice that they would suffer if the interim orders were confirmed and extended, pending the hearing and determination of the petition. The petitioner, on the other hand, would stand to suffer potentially irreversible and irreparable harm and prejudice if the orders sought were not granted, confirmed, and extended. During the highlighting of written submissions in this matter, counsel for the respondent and counsel for the third interested party both submitted at length that any prejudice that would potentially be suffered by the petitioner could be adequately compensated by way of money damages. However, while that would apply to lost remuneration, money damages cannot compensate for other harm and prejudice that would potentially arise from being removed from office and thereafter being reinstated if the petition were to succeed. Once more, I take the position that it would be more prudent and just to avoid the question of potentially irreversible and irreparable harm and prejudice by confirming and extending the interim orders in force for the few more months that it would take the High Court, as the first court seized with the questions raised in the petition, and thus the trial court, to hear and determine the dispute herein substantively. The next issue for determination is where does the public interest lie? The respondent, pending the hearing and determination of the petition, made a resolution. The court must exercise restraint and limit its intervention in the impeachment to hearing the merits of the petition. I further find that issuing conservatory orders to stay the Senate's decision will be akin to directing or interfering with another organ/arm of government in the exercise of its mandate. Close quotes. Article 165, Clause 6 and Clause 7 set out the supervisory jurisdiction of the High Court in the following terms. I quote Article 165, Clause 6 and 7 as follows. Clause 6, the High Court has supervisory jurisdiction over the subordinate courts and over any person, body, or authority exercising a judicial or quasi-judicial function, but not over a superior court. Clause 7, for the purposes of Clause 6, the High Court may call for the record of any proceedings before any subordinate court or person, body, or authority referred to in Clause 6, and may make any order or give any direction it considers appropriate to ensure the fair administration of justice. Close quotes, emphasis is mine.